Well, good morning and welcome to EDNA. We have a jam-packed morning full of fun and excitement, I think, I hope.
Jam-packed, fun, and full of excitement.
Yes.
Okay, let's live up to that.
We've set the bar high. All right, so we'll begin the morning with House Bill 337. Rep. Merchant is recognized to come on up and introduce your bill. You may have to speak loud with the lawnmower, but hopefully they won't be there too long.
Thank you, Senator. So, good morning to yourself and to the members of the committee. For the record, my name is Representative Gary Merchant. I represent Sullivan County District 6, which is Claremont and Croydon. I did submit written testimony to you. I'm not going to read it verbatim, but basically, last summer we had a legislative committee to look at, which sat with Senator Carson on. I want to say thank you for taking the chair on that, by the way. And what came of the committee, it wasn't per se one of the tasks assigned to the committee, but one of the things that became evident during the process was that many of the licensees and interested parties in the public is having appropriate notice of when a meeting was going to be held. And number two is the documents that are going to be shared during the public part of the hearing being available to the licensees, interested parties in the public in time for them to review it prior to the meeting. I didn't realize how important that was until I came off the pharmacy board. I was on the board for 10 years, I was the president of the board for 2 years. We always received the documents in sufficient time for us to review in order to prepare for our time at the meeting. However, what happened was when I came off the board, I didn't realize, it should have been apparent to me, but it wasn't, that when I was on the board looking at the documents, people in the audience had no clue what the documents were. So here we were talking about things that would impact them, but they didn't have the documents that we were talking about. So that was the genesis of why I started to bring this forward. What's nice about this bill was the fact it came through the House Committee 20-0, it was amended, came through the Finance Committee 25-0, and came through the House 387-0. So it was broad bipartisan support. So the essence of this bill is to allow people who are busy, most of the licensees work for a living, and they need to have time with their busy schedules to adjust it in order to attend the meeting. So by giving them a 2-week notice, it's sort of a reasonable time. And by allowing the documents to be shared publicly and made available to them 7 days before the meeting is enough time for them to review the documents and make comments, if you will, at the meeting. You'll note there's an exemption in here. If there is a 91A, particularly when you get into non-public, those documents would not be released. So to protect the integrity of the boards or commissions, particularly when you get into non-public, or something that would be under the 91A, that would be exempt. And that's my story.
All right, thank you. Questions from the committee? Everyone here okay with the lawnmower? I know it's a little challenging.
That's okay.
Is the window down?
Yeah, the window's
It is
down.
Okay.
It's not gonna be too long.
There we go. That'll
There
be
you go.
better. All right, any questions? Senator Altshuler.
Thank you, Mr. Chair. Thank you, Representative. So with 14 days notice, if there is something that a board needs to act upon quickly, is there some sort of a mechanism to allow for a board to gather, be a little more flexible if they have to address any particular item?
My understanding is that would be covered through 91A. It would be an emergency board meeting,
Okay.
which would be part of the 91A. So 91A does address emergency board meetings. So in that case, in my opinion, 91A would cover that.
Okay.
Further questions?
One other question. Yes, so I understand the frustration completely because, being a legislator, if we were constrained by getting amendments out
Yep.
even 24 hours in advance in some spaces, we would be unable to do this work. Is it not maybe appropriate to give a little leeway for materials so that the public is able to view them? But does it have to be 7 days in advance? Is there any flexible, like, why 7? Why not 48 hours? Where did the 7 come from?
The 7 came from the fact that when I was on the board, we mostly got the document 7 days before. So I was just using the 7 days as a format and saying, if we're receiving them 7 days before, why did they become available to the public? The only time we had exemptions, that was emergency meetings. And also, if you wanted to add something at the last minute on the agenda, you could. You may not be able to act on it, but you could at least have a discussion about it. Yep, you're welcome.
Further questions? I guess the chair has one. Typically, the documents you receive, I mean, are some of these requests, what size are the, I'm thinking about the the requirement to have paper copies available to everyone there. I mean, are some of these issues that they're working on, some of them, how big are they typically, I guess? Are they 1 or 2 pages or 100 or 200 pages?
It varies. Most of the time, they're small documents. They're not really large documents. At least I can only speak for the Board of Pharmacy, my time on the board. So I don't exactly know how large the other boards would be. I can't speak to that. I can speak to, if you will, the Board of Pharmacy. The other thing, too, is they're available electronically.
Yeah, certainly your experience, what you've seen.
It's small.
They're small?
That's almost like we have here in the House or in the Senate.
Okay.
The documents are not volumes of paper.
Further questions? Seeing none, we thank you.
Okay, thank you.
Appreciate your time. Representative Diane Schuett. Good morning, Representative.
Thank you, Senator. Good morning, everyone. I'm Representative Diane Schuett. I represent Merrimack 12, the town of Pembroke, and I'm here speaking on behalf of the House ED&A Committee. We got this bill. I don't think the sponsor mentioned, but as you see, it originally came through with an FN. And he pointed out to our committee that the reason for the FN was that an incorrect RSA was cited in the original bill. So our amendment addressed that fact, which actually negated the need for a fiscal note on it. And the language that we also did in the amendment clarifies the information going to the public in a way that satisfied the sponsor's desire for transparency while protecting certain information that OPLC felt obliged to keep confidential. So that was the whole idea of our amendment. As stated, it passed our committee 20-0. And in the final analysis, even though it went to finance and didn't need to, the bill has the rare distinction of final passage in the House on a roll call of 387-0. So, and I think OPLC is here to address some of the questions that the chair and Senator Altshuler raised.
Thank you. Questions? Seeing none?
Thank you.
Well, we'll bring up Doug Osterholt from OPLC. Good morning, Doug.
Good morning, how are you? My name is Douglas Osterhout. I am General Counsel for the Office of Professional Licensure and Certification. I come to you this morning to point out the office takes no position on this bill, but we do want to highlight a few concerns that maybe got by us the first go-round. And I did provide some written testimony. I tried to hit in the written testimony sort of my big primary 3 concerns, and sort of bucket those. And then I provided at the end, it's sort of a weird document, just a sheet of sort of notes so you understand mentally where I'm coming from. So HB 337 amends 310A1D, adds paragraph 5. It creates obligations around notifications and materials for public meetings for boards under the Office of Professional Licensure and Certification. And it also creates obligation for those boards to provide opportunity for public comment during meetings and to provide written comment on anything before the board. So our first concern at OPLC, again, we take no position on the bill, but one of our concerns is that the OPLC currently oversees over 50 professional licensing and certification boards. And we currently those boards currently abide by the provisions of RSA 91A, which governs access to governmental records and meetings. Public body is any legislative body, governing body, board, commission, committee, so they clearly fall under that. Under an RSA 91A, meetings must be noticed at least 24 hours prior to such meeting, and there's no obligation to provide materials to the public prior to the meeting. Governmental records become available for public inspection after the completion of the meeting of the public body under RSA 91A 4.2. So it's a right to know request, essentially. Under the proposed language of 337, the boards, councils, and commissions under the OPLC, and only the boards, councils, and commissions under the OPLC would have an obligation to notice public meetings 14 days in advance and would be obligated to provide materials pertaining to those meetings no less than 7 days prior. Additionally, there's no obligation under RSA 91A to allow for public comment, either through spoken testimony or written. The proposed language would create an obligation for the boards, again, administratively attached to the OPLC, to do both. I think an example of where the boards under OPLC are being singled out, we can look to the Boxing and Wrestling Commission, which is currently administratively attached to DAS. So if we look at boxing, in order for them to have a meeting under DAS, they would have to have 24 hours notice. They would not have to provide any materials beforehand, and they would have no obligation to hear public comment or written testimony. A simple shift, which is proposed under HB2 to OPLC, would flip that all on its head. Suddenly there's a 14-day notice. There's a 7-day mandate to provide materials in advance, and there's must provide opportunity for public comment and written comment. And the only change there is what agency the board is administratively attached to. It seems like the boards under OPLC are being singled out, and it's not particularly clear why. But the boards under OPLC currently go above and beyond what's required by law. So we often provide meeting dates a year in advance. So they're all posted on our website now. So every planned meeting for the year is up on our OPLC website. And then the boards provide opportunity for public comment and written comment. So that wouldn't change, other than it would now be a requirement under the law. Our second concern is legal concerns around the implementation of 337, last minute changes to meeting agendas and emergency situations. So under the proposed language of 337, boards administratively attached to OPLC, again, must make materials available to the public 7 days before a meeting. But it is in there, provided the materials do not contain information exempt from disclosure under RSA 91A5. Examples of information exempt from disclosure would be test questions, scoring keys, other examination data used for licensing exams, confidential commercial or financial information, other files that the disclosure of would constitute an invasion of privacy, so PII, home addresses, those sort of things. So exempt material often comes before the boards for consideration, which would mean that all materials would need to undergo thorough legal review before dissemination to the public. And meeting packets often contain, to your question, Senator, hundreds of pages of documents, especially for the larger boards, Board of Nursing, Board of Medicine, and there are always multiple public meetings per week. And a comment on the fiscal note, I drafted 3 separate fiscal notes attached to this bill. I did provide I think in the last fiscal note say that in order to accommodate that, we would need to hire an attorney too to make sure there was adequate experience. Labor grade step 1, that would start at about $94,000 a year. There's a lot here. I'm actually doing the short version, believe it or not. I think it's important too to point out that board members currently receive information related to the meetings 5 days in advance of the public meeting. We use a software solution called Onboard for that, and Onboard prohibits the sharing and printing of documents so that the board members have to read and review those documents in Onboard, and that was a deliberate choice in an effort to protect the confidential information that could be contained in those packets. Every obligation to disclose a document reviewed by a board creates another opportunity for the unintentional disclosure of materials exempt from disclosure under 91A. And I think that really needs to be highlighted because we deal with sensitive materials, we deal with applications that contain social security numbers, home addresses, emails, all sorts of other personally identifiable information. Again, the materials discussed in meetings will become subject to disclosure after public meeting has ended and are available through right to know request. I think a major difference, though, is that right to know requests need to be pointed. And often when we receive a right to know request, it won't be for an entire meeting packet, it'll be for a particular section. OPLC responds to such requests appropriately, disclosing what is allowed, denying what is exempt, redacting exempt information on an otherwise public document. Again, for example, the home address of a licensee. Another concern that we have arises from the language that permits the chair of the board to add additional items to an agenda within 7 days of a meeting if, at the chair's sole discretion, the public interest in the board addressing the matter outweighs the public interest in timely access to materials. In such circumstances, materials must be made, this is in the law, it is a shall, available as soon as reasonably practical, and it is not practicable to make the materials available at least 1 day prior to a meeting. Paper copies must be made available at the meeting. So the OPLC foresees a situation in which a board chair adds an item to an agenda the day before the meeting. There's no time for a proper legal review of materials associated with that new agenda item. And before any legal review has occurred, paper copies must be made available at the meeting. So the OPLC is concerned that HB 337 could have unintended consequences resulting in significant harm to the public in the form of unauthorized disclosures of confidential information. On the flip side, if a board chair left an important item off an agenda because there was an inadequate time for legal review, the language of HB 337 could have a chilling effect on the boards. Finally for this section, thank you for all the time this morning. After HB 337 passed in the House, General Counsel with DOJ approached OPLC and raised concerns that the language only addresses regular meetings and is silent as to how emergency meetings under RSA 541A33 involving emergency action against licensees are to be handled. So those are emergency situations where a board can take action against an individual's license if they think there's immediate threat to the public welfare. And then finally, I'll wrap up, but there is some uncertainty within the proposed language. HB 337 requires materials to be provided. It is unclear if that has the same meaning of governmental records under RSA 91A. It is unclear what remedy the public would have if the boards failed to meet their obligations under the proposed language. If a board failed to post materials in a timely fashion, for example, would members of the public be limited to contacting DOJ? Would they have the same ability to petition the Superior Court for injunctive relief that is granted under 91A7, or the ability to contact the Ombudsman's Office under 91A7A? There is a different standard for the boards. Does it also create a different remedy? That's unclear to us. And I want to thank you for giving me ample opportunity to speak this morning. Again, we take no position on the bill, but we did have these concerns we thought we should highlight. I am available for questions.
Thank you. That is a lot of information.
It's a lot. I'm sorry about that.
I think I got notes enough, and
Yeah.
we appreciate it.
I also, the last page of that document, like I said, is more just a bulleted version. And there are things we're already doing, and that's sort of highlighted in here.
Senator Carson.
Thank you, Mr. Chair. I have to tell you, Mr. Osterhaus, I'm really kind of disappointed in your testimony. We sat there last summer, last fall, working on this issue, and not once did OPLC raise any of these concerns. We had that study committee because we felt as the legislature that there really needed to be an understanding about what were the duties and responsibilities of OPLC and what were the duties and responsibilities of the board. This legislation came from that study committee. A lot of hard work was done between those of us who were sitting on that board, that committee, as well as OPLC and the boards that were there. Now, it's very unsettling to me to hear that there's all these problems when OPLC wanted to do this, because one of the issues that came out of those hearings was the fact that there was a real lack of communication between the board and the members. And the members felt that they were at a huge disadvantage because they had no idea what these boards were doing. So this is what we had agreed upon. And I really find it, quite frankly, disingenuous. At this point, you folks come in here and start ripping it all apart. I mean, I really wish Director Courtney was here, because we were all on the same page. I don't know what happened if you folks showed up in the House and talked to them about it, but to come here at this late date with all these issues, I have a really big problem with this. And quite frankly, I'm really disappointed. I'm very, very disappointed in OPLC and how you have handled this issue. If these things were a concern, they should have been brought to the House, where the House had the time and the expertise to go through all of this. Now you're telling us we have no position. Oh, but by the way, 1, 2, 3, 4, 5 problems that you find. Mr. Chairman, I don't know what to say. Oh, sorry, I'm just going on and on.
That's okay.
I'm very disappointed. We did a lot of work on this, and you folks were sitting in the room, and I know, Mr. Osterhaus, you were sitting there as well. And not once did anybody from OPLC raise any of the concerns that you are talking about here today. I don't understand what's going on here, and I'm going to have a conversation with Director Courtney to find out why you're coming in now at this very late date to make these an issue when you could have addressed it while it was in the House. Thank you, Mr. Chair.
Mr. Rosehill,
A response to that. I appreciate that sentiment, and even without the microphone, I heard you loud and clearly, because I knew I was going to come in here today and disappoint a lot of people based on the testimony that I was providing. I do remember that the bill before us was introduced the second to last meeting at the close of the meeting, and I don't remember any formal discussion about this language in particular. The bill was proposed, there was no formal discussion, and at the next hearing, it was part of the recommendations. I did have a conversation with Representative Carol McGuire about the concerns I had at that time. I also used the opportunity in the fiscal notes to raise some of the concerns that I presented here today. Unfortunately, I wasn't able to testify in the House. I believe the executive director worked with Representative Merchant to carve out some of this language here today, but I wasn't present at that time. So a lot of these concerns were things that I brought to my attention or I found in my reading after the fact. I'm sorry to disappoint, I truly am, but I am trying to get this right. We're not opposed to the idea and concept, but I do think this language, as is right now, does have some issues in it. I would absolutely be willing to work with anybody to try and clear this up, maybe tailor it a little bit more narrowly, address the situation. But as it is, I do have these concerns. I believe there was something else I was going to say, but it's lost me.
All right, Senator Carson.
Thank you. What I hear you saying, Mr. Osterhaus, it
Yeah.
seems like there's some sort of disconnect over at OPLC, that people aren't talking to each other. That has me very, very concerned, because with the legislation that we are considering, not only here, but others that we have looked at, that the department is going to be taking on a huge responsibility in governing these boards. And if you're not talking with yourself back and forth, how are you going to be able to do that? One of the issues with this is the fact that there's a lack of communication between the boards and its members. So now I hear you saying that OPLC, they're not even talking to each other, that you don't have your act together. And if you don't have your act together, how are you going to oversee all these boards? You're not going to be able to do that. It was my understanding that through the committee that we had, you folks were ready for this. You were going to be able to do this. Now I hear you saying, well, we didn't know, we're talking back and forth, and oh, we need to hire more people. There was no discussion about hiring more people to implement this. We were told, yeah, we can do this. This is not a problem. Now you come forward at this late date and you're telling us, oh, we have all these problems. Again, I'm going to have a conversation with Director Courtney about this, because based on your testimony, you folks aren't ready to deal with any of this. It's going to be a disadvantage, and it's going to end up hurting the boards. And that's the last thing in the world we want to do. These boards govern an individual's license, their ability to work. And that's one of the reasons why we had this, was because of communication. That things were happening that affected their jobs, and they had no idea, because the boards were not communicating with the members that they govern. And you folks were good enough to take that over. And you said, this is what we want to do. So now we do what you want to do, and now you come in and complain that you have all these problems. Again, I'm going to have a conversation with Director Courtney, and I apologize for being a little strident about this. We did a lot of work on this, Mr. Osterhaus. You know that. You were there. And it was a missed opportunity on the part of OPLC to come forward with their concerns while we had this commission. Representative Merchant and House ED&A has done an incredible amount of work to implement what OPLC has asked for. And now to have these concerns come forward about this at the very last minute, it's, in my opinion, it's very disingenuous, and I'm very disappointed in the department. Thank you.
Mr. Rosso?
Thank you for an opportunity to respond. I understand that frustration. I do want to point out, Executive Director Courtney and I have a very close working relationship, and there's a lot of open communication. She attended the hearings in the House, and there were 4 amendments. This is not the first iteration of this bill, and some of this language that is in the amended version of this bill, I was not present for a public hearing. This was my first opportunity to speak on that, on the new language. As far as the boards go, if the legislature believes that this is the appropriate route and path, the OPLC will absolutely be able to step up and implement anything that you put in this bill. We are not opposed to it. We just want to raise some concerns. If it is the legislature's decision to move this forward, we will make it work. It will happen. I will assure you of that.
Further questions? Senator Altshuler.
Thank you for taking my question. I appreciate it. So I am dialing back to some of the concerns that I expressed with Representative Merchant. I did not work on this summer commission, so I am coming to this from a different perspective. I would like to know, in your concern number 2, on page 2 of your testimony. I am also wondering where the 7 days before a public meeting, is it, how does that, because I have 91A here, and I'm looking to find where the justification is for making things like test questions, scoring keys, available to the public. I recognize that not all things discussed by the boards would be protected, you know, and I do hope, I don't not believe you, but I don't know enough about the application of private information that you were talking about. I don't know, that maybe that is covered here. I think I would like to hear a little bit more of that. But in the moment now, for boards that do have testing and proprietary information to be able to acquire a license, how would 337 impact the way that those boards administer to those pieces of information or propose changes within their own board because it's not protected?
The boards would still have full access to the material. So a lot of the material that wouldn't be disclosed would be the physical paper sort of documents, test questions, things of that nature. I believe the boards would still be able to have those conversations in non-public session. It wouldn't impede them from having those. The risk is more on the side of unintentional disclosure because of requirements in the current language.
Paula? Yep.
So some of the sticky places that we have been working in this committee around licensures is what the standards will be in each profession. And those standards are OPLC and board standards. They are not legislative standards. So if it is not protected government information, what would stop anybody from being able to access all of, you know, previous discussion materials about changes to testing and licensure for real estate, nursing, anything that requires a standard test to enter the field? It would almost be like putting out the answers the year before, wouldn't it? Like,
Correct.
This is what hearing some of the other testimony we've had from other bills, I'm now getting a bigger picture of what's out there and how it relates. So how does that stay confidential if it has to be in here released? Where's the space in 91A to keep that under wraps?
So under 91A4, an individual could request any of the meeting materials discussed at a public meeting after the meeting took place. In those instances, typically when we receive 91A requests, it's not for an entire meeting packet, it's for a particular part. Those would still undergo legal review. Anything that could be disclosed would be disclosed. If anything was exempted, we would withhold that. We would provide legal justification for doing so. And then there are certain documents such as a licensing application, which again might contain a social security number, a home address. That is considered a public document, but we would do a review and redact anything that would be exempt from disclosure under 91A5. So it's on the back end. It's not every single document before the board. It's only the material that's requested. And again, typically when people make their request, it is narrowly tailored to their subject matter interest. So application or whatever it may be that the board discussed. It wouldn't be, I'll use an example, the full 200-page document before the Board of Medicine.
One more? Yep.
Is there anything that prevents somebody from asking for that entire board meeting minutes and being able to receive that from you?
No.
And are you saying you would, if somebody requested that and you had to give that over, your office would take the time to redact, for instance, test questions or application addresses so people aren't doxxed?
Correct. So I point your attention to the actual language. RSA 91A4, minutes and records available for public inspection. After the completion of a meeting of a public body, every citizen during the regular or business hours of such public body and on the regular business premises of such body has the right to inspect all notes, materials, tapes, or other source used for compiling the minutes of such meetings and to make memoranda or abstracts or to copy such notes, materials, tapes, or sources inspected except as otherwise prohibited by statute or RSA 91A5. We are required to have a response to the individual within 5 days. If an answer can't be provided in full in 5 days, what we will do is we will send out a letter to the requester in 5 days, acknowledge receipt, and then, as permitted by statute, provide a reasonable amount of time, typically 1 more business week, sometimes 2, for a very large request. The largest I've ever done, not with the LPLC, with a different agency, we requested 90 days, but that was a very, very hefty request, and we also stagnated the answer in that instance. Or staggered, not
Further
stagnated.
Sorry. We understood. Further questions?
I haven't even had my first yet.
Well, we'll give you a chance now to go grab. Thank you. We appreciate your testimony. I have Steve Rancourt signed in favor of the bill, but not speaking. Anybody else that wishes to speak? Yes, come on up. Turn your mic on and please give us your name.
Good morning. My name is Regina Hugo. I'm a licensed alcohol.
I'm sorry, could you say it once more? I missed it.
Regina Hugo. I'm a
Regina.
licensed drug and alcohol counselor. I'm here today to testify in support of this bill. As a license holder, I strongly advocate that every Office of Professional Licensure and Certification should provide notice of public meetings and give an opportunity for public comment. In my personal experience, I feel that I and other members of this profession have been failed to be adequately notified by the board that certifies us regarding recent rule changes for our MLADAC certification requirements. Over the past 9 months, I have invested a significant amount of time and finance towards a license aligned with the rules set at the time. I can no longer continue to work towards this licensure due to the recent changes without setting back my personal family goals. I would have appreciated
Okay, take your time.
I would have appreciated more of an honest effort from the board that governs my certification to adequately render notice and publish public minutes in a timely fashion. I sincerely am disappointed to miss the opportunity. Excuse me, I'm sorry.
You're fine. Take a moment if you need.
To voice my concerns during public comment due to subpar communication. Public meetings and public comment are vital, as it is the only way a license holder or a public member can professionally, informally, and legally communicate with a member of a licensing board. I support this bill to ensure that I and other license holders and applicants will receive a professional courtesy of notice of public meetings and be given the opportunity to voice concerns and collaborate, as most of the information discussed in these sessions directly impact the license holders and applicants.
will you take some questions from the committee? Any questions from the committee? I'm not sure we have any, but thank you. We appreciate you coming in. Anyone else that would like to speak? All right, seeing none, we're going to close the hearing on House Bill 337. All right, Rep. Pearson is here, so we'll open the hearing on House Bill 215 and recognize Representative Mark Pearson, who's the
Thank
prime
you,
sponsor.
Mr. Chairman. I think this one will be easier. 40 years ago, my Aunt Janet, RN, was part of the initial trial group of nurse practitioners in Massachusetts. Until then, there were no rungs between an RN and an MD or DO. There was a big gap. And she became a nurse practitioner when that new rung was added in between RNs and MD DOs. She moved up in her career, she got a good raise, and she enabled the physician she worked for to do what he was more specifically trained for. Nurse practitioners, an intermediate rung, helped everyone. Before us is a bill about adding a different rung. I filed it at the request of the New Hampshire Association of Counties, the nursing homes of which need a lot of help in terms of staff. Should this rung be added to the ladder, people thus licensed to administer medication after they've been trained to do so will be moving up a little bit in their careers. They'll probably get a little raise. And it will enable those in rungs above them to focus more particularly on what they're specially trained for, because somebody is now doing some of these other things. This bill, if passed, will help individual workers, and it will help facilities who have a labor crisis. Thank you, Mr. Chairman.
Thank you for your testimony. Any questions from the committee? Yes?
Yeah, thank you.
Senator Ralston.
What was the name of the group? I'm sorry. I think I wrote it down incorrectly. The
The New Hampshire
Association
Association of Counties.
of Counties. Thank you.
Further questions? Seeing none, thank you for your testimony. So we have Brian Clark from DHHS.
Thank you, Senator.
Good morning.
Good morning. So I'm here to speak on what the bill does. So it expands the current existing reimbursement program. Currently, the Department of Health and Human Services will reimburse licensed nursing assistants who complete a nursing assistant training program if they're employed by a nursing facility. This will expand that reimbursement program so that if a licensed nursing assistant chooses to complete additional training to become a Medicaid nursing assistant, that additional training can also be reimbursed.
That sounds pretty simple. Questions from the committee? Thank you. We appreciate your testimony.
Thank you.
Kate Horgan. The challenge is on, Kate. Can you make it more simple than that?
I'm going to try. Kate Horgan, New Hampshire Association of Counties. We do support the bill. We worked with Attorney Clark over the summer at DHHS to make sure we had the language correct so there would be no issues. I will note that Chairman Pearson and Attorney Clark both did a great job. The only thing I will add is that this passed out of Health and Human Services 20-0 and was on the consent calendar.
Thank you. Questions from the committee? Seeing none? Oh, yes?
Are we talking about administering only oral medications or IV medications? And I'm in this space right now because I have a loved one in a skilled nursing facility.
Yep.
And so,
Thank you for
we're there for the med carts coming, and So before this train rolls down, I was not in the House committee, so I'd like to hear
Sure.
some of
So
that
thank you for
information.
the question, Senator. So this bill authorizes them the training that they take is for very specific medication that they are allowed to pass out. So things that are extremely complicated still would fall to the RNs, or things that I don't have the specifics for you. I can certainly get that from the nursing home administrators. Unfortunately, they're in union negotiations this morning, so they were unable to be here. But I can certainly get the specific list for you on what they are allowed to pass and what they are not. But I do know they are not allowed to pass anything that they have not been trained in distributing.
So is this basically the medical assistant certification that they can currently get?
It is, yes. They can already get it. The program already exists. This would just allow DHHS to set up rules so that they could get tuition reimbursement. So it's not changing any of the duties that they are getting.
Yes.
It is just changing that they could get tuition reimbursement.
Got it. The interesting part is my wife and I just had this conversation at the dinner table the other night. She's trying to explain to me all of the levels of licensure. She's an LNA.
Yeah.
This is all new to me.
Yeah.
And we happened to talk about medical assistance and the distribution of medication, so I guess it was relevant. Thank you.
Yeah. So we are not changing any of the rules that they are already allowed to pass.
Got it.
Just tuition reimbursement.
Further questions?
Thank you.
None? Thank you, Kate. Anybody else that would like to speak on this bill? Seeing none, we're going to close the hearing on House Bill 215. Rep. Merchant is back. All right, so we will open the hearing on House Bill 136. Welcome.
Thank you, Mr. Chair.
You got to do a good job. You're the only one on the sheet.
This is relatively a simple bill. At least I think it's simple. For the record, my name is Representative Gary Merchant. I represent Sullivan County District 6, which is Claremont and Croydon. This fundamentally allows the advisory council to the prescription drug monitoring program, which is the common name of it, to have the opportunity to voice an opinion about a rule before it goes to JLCAR. And at that point in time, they can hold a roll call vote to either support or oppose the rule. And I think it's important that when the rule goes to JLCAR, that the opinion of the advisory council is shared along the journey. That's fundamentally what it's all about. It does not take away the department's obligation to be responsible for the rule. It's just requiring that the advisory council's opinion is heard. That's it.
Thank you. Questions from the committee? Senator Altshuler.
Thank you. So is the proposal for this legislative fix or change to RSA 126 due to the Department of Health and Human Services feeling that they weren't being heard at the JLCAR level? Is that where's you just said they have to hold a roll call. So did they ask for this because they felt like they weren't?
It's basically codifying best practice. I think the concern was that it's not required for them to have a roll call vote or to have an opinion shared before the rules move forward to JLCAR. So all this is doing is codifying the best practices for them to be able to review the rule, make their opinion heard, and at that point in time, hold a roll call to support the opinion, whether support it or to oppose it. It doesn't change the department's authority for the rulemaking. This is coming from the advisory council, and it's coming from myself specifically because I sit on the council as well, and I just want to be sure that the voice of that council is heard along the journey of rulemaking.
Maybe I'm missing something, but which advisory council is this?
There is if you look at the statute, it's actually called the Controlled Drug Prescription and Safety Program. But we normally refer to it as the Prescription Drug Monitoring Program.
The PDM, yeah.
PDM,
Yep.
PDMP. But that's the common name, that's not the legal name.
That's fine. I just couldn't see it in the bill. I
Center,
hadn't had an
yeah.
opportunity to refer back to the statute, so thank you.
And I want to share, share with you folks here, this was drafted in collaboration and cooperation with the department themselves. And so it was not something I did without their support. And if Mr. Holt's here, he can probably testify to that as well, but that was the intent. I worked with Mr. Holt, I worked with Mr. Williams in the department to draft the language that you're now looking at.
Thank you. Further questions from the committee?
Just
Senator
one
Alshaw.
minute. Just for clarification, the advisory council is in collaboration with DHHS to discuss potential rules. And then subsequently take a roll call in full disclosure of everyone's opinion, and then send that along so that there's complete transparency and that all stakeholders have been heard. Is that correct?
That's correct.
Awesome, thank you.
Further questions? Seeing none, we thank you.
Thank you.
Anybody else that would like to speak on the bill? That's all I have on the sheet. There's not a big crew to choose from. All right, we're going to close the hearing on House Bill 136. Philip, do we know where Senator Carson is? Okay. I'll take a motion to go into, well, I don't know if we want to or not, because I don't want to exclude, I was going to say we could have conversation, a discussion, but
Yeah.
probably might need to take, we'll take a recess until 10:15, because it's going to take her a few minutes.
that makes sense.
And then we'll come back and hopefully we can do a little executive work.
Sure.
All right, we'll be in recess till 10:15.
Mr. Chair, I make a motion to move into
Okay,
executive session.
hold on one second. We gotta get our mics on. All right, Senator Carson, do
Thank you, Mr. Chair, I move that we move into executive session.
we have a second?
Second.
Seconded by Senator Gendro. All in favor? Aye. Okay, we are in executive session.
Okay.
I guess, where do you want to start? We can, 238, you want to start with that one? Since I distributed an amendment, although I can't seem to lay my hand on mine right this second. I don't know what I did with mine.
There was only one word though, Senator Pearl, that was not changed.
Yes,
Yeah.
there's a second amendment here that has been drafted to fix that, but personally, I don't think we need a second amendment. I think we can fix it in the first one
Well, it's the, where it was reviewing, interpreting, and
and
disseminating.
clarifying.
We want
Yes,
clarifying.
that's what this amendment fixes, because I caught it.
Okay.
But I don't think we need a second amendment. I think we can just do a committee amendment to the first one
Okay.
and fix it there.
Sounds good.
That was my thought.
Which bill are we taking up first, Mr. Chair?
238.
Okay.
Okay, I found my amendment. It's actually in my book where it should be. That's nice.
Yep.
Okay. So Senator Perkins Polka and I met with HHS and had a discussion with them about the concerns that we heard in committee. And they came to the table actually in very good faith and brought some proposed language back with them and actually added back in portions of what we had been contemplating taking out in Senator Gendro's amendment. They felt that it was workable and it was important. And so that is part of, let's see, I can see how it's numbered on the new one here. That is section 4, I guess. Am I reading that right?
yes.
Yes, I'm trying to look at the right amendment here. Yes. So we had proposed to take out section 4, originally Senator Gendro's amendment had. And then HHS came back and actually asked us to put it back with some, there were minor tweaks to it, right?
Yes, with some minor tweaks to it.
I'm
So
sorry.
essentially what DHHS asked for was if we were going to reinsert what had been section 5 in the version amended by the House, that we add in the quarterly
Oh, yes, there we go,
language.
first sentence, I got it.
And then I believe either the 60-day turnaround was already in there or we sort of solidified that language.
So so lines 32 through 34 on the amendment, and the amendment is 1452. Just to make sure we're all on the same amendment.
Oh, and I'm sorry, Chair, I forgot one more thing, which was that the department also added in the constructive suggestion that any feedback be discussed at the next council meeting.
That's correct.
Is that where it ends? Because I just have the next council meeting.
No, there's a page 3.
Okay, let's see, I don't believe I have page 3. Okay. Thank you.
Oh my gosh, too much stuff. Okay.
Did you all not get page 3?
We got
You did, okay, so Senator Carson was just, all right. So if you look on page 2, beginning on line 32, which is where section 4 begins, that is the language that Senator Perkins Polka was talking about adding in the quarterly reporting. And the reason they wanted to do that is so that they were able to not have to tie up resources answering questions weekly or monthly, or they felt quarterly was reasonable for them to receive input. And
So within that addition,
yes,
I was reviewing this with Senator Gendro earlier, and just to clarify, on line 32, it says the council shall provide the department with recommendations no more frequently than quarterly. So they're not required to produce these recommendations
Quarterly.
more than quarterly, but they may have, the option is open to have communications in between.
on other issues, yes, I would assume that would be the case.
Okay, I don't want to say it out loud so that we all understood it the same way, that it doesn't preclude any communications. It's just that they have to on a quarterly basis.
Right, so additional communication would be welcome to be submitted to the department. I think the department's obligation to respond would
Right.
be
Would be
quicker.
quarterly.
Yep.
Yes.
Well, so the department shall respond in writing within 30 business days, of the council's recommendations. Okay, got it.
Mr. Chair,
Yeah.
if I may,
You may.
is this a little cumbersome? Because I see that here on 27, significant changes proposed by the department relating to or which may impact any of the practices, policies, standards, rates, budgets, funding formula, or rights pertaining to eligibility or provision of supports. That's a lot. That's a lot of things. So if you go down to section 4, the one that you're referring to, they're going to provide the department with recommendations for improving service quality and quality assurance, and no more frequently than quarterly. And then the department has to respond in writing within 30 business days of the receipt of their recommendations. I'm just kind of wondering if that's a lot, considering that they're looking at all regularly review information on the quality of services and make recommendations on all these things. It just seems like this is going to take up an inordinately amount of time.
So the assistant commissioner was comfortable that they could handle this within the abilities that they have within the department. And they were comfortable, and they actually came back with this language and said, we can do this and we want to.
Okay, if they can do this, I mean, with each recommendation, a detailed plan, that's a lot of.
I'm leaning on them because they told me they could do this.
Yeah, and RSA 171A is about eligibility, so a significant change would be to take somebody out of eligibility or add someone in.
Right.
It's not programmatic. It's just,
Yeah.
it's people eligibility.
And their one ask back, if you go to page 3, beginning on line 1, is that within 60 business days of the council meeting would put it on their agenda too. So that the council would,
Yeah,
so that it was occurring on both sides, with HHS and the council reviewing.
okay, sorry.
Now, we do have members from the council here. Is there any questions from the committee that they'd like to ask?
No.
Yeah.
I can bring them up if there's a question you'd like to ask.
Oh, not of them.
No, of the council.
Oh, no, I'm sorry.
No, that's okay.
I'm
Okay.
looking at all my
Well, they are
papers.
here as a resource if we need them, okay?
Yes.
So there was a request from the
Right.
council, and that's the email that I sent you. I know we all.
That
have a
was
bunch
my
of
next
papers.
question, and then you offered to this thing, and I was like, wait,
So,
2.5, I'm a 1.5 cup in, Howard. 1.5.
this is late for us, it's almost lunchtime.
Oh my God. Rude o'clock.
So I did provide you with an email of some suggested language from the council. I certainly am open to thoughts and comments from the committee on that.
And that would be added after section 4.
That was their suggestion, yes.
Okay.
Well, I think the idea of clarifying that, what I was asking about before is it doesn't mean you can't participate. It's just that you must participate in that quarterly space, and here's the way that we'll respond, that it is not restrictive. So I think that's a good clarification.
Yes, and I think having it on the record
Mm-hmm.
is important, and I think the intent, at least on my part, I don't want to speak for Senator Pearl, but I think he shares this, is that it's important that we all had this conversation with the department as well, and I think the feedback is noted, and I think, they're working to implement some changes as they've noted, and so, we'll see how this all goes, but I think the changes we've made provide a professional and productive feedback loop that I hope is productive for everybody.
Well, I was pleased that, excuse me, the department came stepped up and came back with actually a little more restrictive language than kind of back toward more the original bill. And I was pleased that they felt they were able to meet that task. And as Senator Carson had noted, to me, it looks like a good amount of work for them, but they were very comfortable they could do it. And they were very much, I felt from the meeting, they were very much wanting us to put that back in. So I was pleased to see that commitment. Yes, Senator Carson.
Thank you, Mr. Chairman. On page 3, beginning on line 23, which authorizes electronic participation, I was holding this, looking at it, but yesterday in Judiciary in the afternoon, we had a bill, it actually passed the House, that is going to allow state boards to hold their meetings electronically. So I was concerned, in fact, that's why I didn't have this copy, because I left it upstairs, that we might have, if the hearing kind of went sideways, we might have to address that, but
good catch.
it did not go
Okay.
sideways, so I'm hoping that in Judiciary, we can take care of that and pass that.
Excellent.
And allow the state boards to meet electronically. I think it would be very, very helpful, and I'm sure that it would help participation.
So do we have a motion on 238?
I move OTP. Oh, wait.
Yep, you have to move.
Do we have, no, didn't we do that already, to
Nope,
open discussion?
we didn't.
Oh, we just
We
launched
just started
in.
talking.
We don't have to.
We just started talking.
Well, I learned that we don't have to. We can discuss without a motion.
There we go. I
least
move
that was what I was-
OTP.
Do we have a second?
I will second.
All right.
Okay.
Right.
And I move to pass on amendment number, where'd it go?
1452.
1452.
I'll second.
Excellent. So
So discussion on the amendment.
may we
Oh, we have to
insert the
make a
bit
change.
from Ms. Patrick in between lines 12 and 13 on page 3? And change
So.
the word interpreting to clarifying on page 2 on line 30?
Yes, page 2. Yep, so we need to change interpreting to clarifying. Yep. Philip, have you got that? Right. And what's the committee's feeling on the language for adding in this language?
Great. I'm
That's
down
fine.
for it.
No, they should have the ability to communicate
Yeah.
as needed, and not feel restricted that it has to be done quarterly, so.
That's the wrong email.
So I think as long as it's clear that the department's obligation to respond is quarterly, then no, we certainly don't want to, the intent was not to restrict the ability of folks to communicate with the department.
Okay, I have somehow misplaced that email. I have a different email, and it's probably in this pile.
Take this one.
You know where it is? I bet it's on my desk.
Another copy of it?
Because we talked about it back in my office.
The only thing I guess personally, I don't know that I feel like we need to insert the clarifying language. I don't oppose it, obviously, because it's the intent. But I just want to make sure if we do, this quarter limit is not intended to restrict the council's ability to comment on rules, regulations, proposals, or other initiatives impacting the quality of services for people as needed throughout the year. I mean, there is nothing in here that does restrict that, but I guess I would sort of add to the end of this, which are not part of the council's formal duty. Like, there needs to be some kind of clarification that what she's discussing are matters outside of,
What's in this document?
yes, outside of the procedure we have set up for this formal feedback loop, I guess. Or at least that's how I read Ms. Patrick's comment, if you do.
I would agree.
So you want to add the words what?
Well, I don't have the perfect words, let me think on it, but like, I think what the intent of this email is that what they're saying is these procedures, this sort of quarterly formal back and forth, doesn't mean that the council can't participate in other matters that are before.
Right.
the
So
board.
the quarter, let's go back and review lines 32 and 34 real quickly. The council shall provide the department with recommendations for improving service quality and the quality assurance and continuous improvement systems no more frequently than quarterly. That doesn't mean they can't talk about other things at any other point in time they want to.
Right,
Right.
which is what this clarifying language is.
But I think,
Not this
I'm
this
just not
quarterly
certain.
limit, not intended to restrict.
I'm not certain it's needed to, because the restriction is very specific as to what it's restricting. The service quality and quality assurance and continuous improvement systems. That's what the quarterly restriction is.
Well,
But
right, and this considering the thing from Ms. Patrick, what we heard in testimony is that there was some difficulty in the council feeling and being heard along the way in
Yes.
multiple arenas. This is specifically about service
we do it?
quality assurance, and in continuous improvement systems. This is the enabling that we can talk about other things, and we would like to have that
we put a
access to
simple
you.
sentence right there after that and say communications and all other issues are
Subject
not
to this
restricted?
process, or, yeah.
are not restricted by this quarterly limitation? Would that do the same?
I think it's 6 one, half a dozen or another. Is-
I just think putting it right there would be very clear. So if you want to
I think the reason, but it sounds like the reason she put it, and, you know, I'm not to be argumentative, but the reason it's prescribed after is that there are response details outlined with the shall respond in writing within 30 business days. Like, it's the, okay, we are gonna do this quarterly, and then the department's gonna respond in 30 days, and then after that, the council can do their response. So like the whole process is set up. And then this is like, now that we've got that settled, just wanna, like I said, 6 one, half a dozen or another, not a hill I'm gonna die on, just,
Any thoughts from you guys?
Well, I think that I do like this language because, again, I think people will read this and say, no more frequently than quarterly. And you can look at that and go, oh, we can only talk to them every quarter. What about the everyday things that come up? And I think this makes it clear that you can reach out to them at any time to talk about anything. And I'm wondering, you know, this quarterly limit, as described, is not intended to restrict the council's ability. I think you need to make that statement.
yeah, and the quarterly limit is like, what has to happen within that quarterly limit is
Right.
very
Narrow.
No.
Very
narrow and
narrow.
prescribed in
Yep.
that section. And then I just think adding
Yeah.
a section
Either way is
4
fine with me.
would be,
Yeah.
like, just
Because
so we know,
It
just to
can be a
clarify.
little intimidating, quite frankly, to see that, oh, only quarterly?
Well, that's why I
Yeah.
thought putting it
Yeah.
right there
We gotta
after
wait
that
4 more
sentence.
weeks.
I think that
Yeah, that's the right
right
spot, I
after
think.
that sentence would
Yep.
be appropriate.
So line 34,
Yeah,
This
And
quarterly limit as described is not, we could take out section 4. We just say this quarterly limit as described is not intended to restrict the council's ability to comment on rules, regulations, and just
Yep.
put it right there. To me, when I read through it and I go, okay, here's the quarterly limitation and this says what it doesn't do, and then it goes on the rest of it. But
does
like I
that
said,
work for you?
Yeah,
okay. So
so just take this
I'm
language.
can I get a
and
head
put
nod
it
if you're
in.
okay with that?
I am, but if I can make another, oh,
I did just have a couple questions, if I may. Did you all pick them up?
Would you like them to come up and comment, or is the committee comfortable with what we're doing?
there's one more change I'd like to make, so if I can.
Okay, give us a second.
Give us a second. Because now you're gonna be adding this language here. I think that the section that deals with, right after that, the department shall respond in writing within 30 days of receipt. I think that this should be a separate section and separate that out.
Yeah.
Because here, you're talking about shall provide the department with the recommendations for improving service quality and no more frequently than quarterly. And then you're gonna say this quarterly limit is not intended to restrict the council's ability to comment on rules, regulations, proposals, or other initiatives, blah, blah, blah. And then you're gonna start talking about the department. Shall respond in writing within 30 business days of receipt. I think that when you start with the department, that should be a separate section. So maybe a section 5 to separate that out, because what you're talking about at the first part of it is you're talking about providing recommendations and the qualifier, and it's no more than quarterly in these instances, but you can still talk about other things throughout the year. And then you're going to go on to say the department shall respond in writing within 30 business days of the recommendation. And you separate it all out and you make it very clear what's happening here, what's happening here, what's happening here. I'm just concerned that that's going to get too big, and maybe the nuances here might get lost a little bit.
So do you want to make this a separate section? What
No,
they suggested?
no, because if you look at paragraph structure, sorry, I'm getting my teacher hat on. If you look at paragraph structure, you want to get all the information that, that deals with one particular issue, which is dealing with making the recommendations in one paragraph by itself. And then now you're going to talk about the process, which says the department shall respond in writing within 30 business days of receipt. So that should be its own section with A, B, C, because those are the qualifiers. Does that make sense to everybody?
It makes sense to me, yeah. So
Well-
we would create a new paragraph right after the
Right, it
insertion
would
we just
be,
made.
yep. When you start with the department,
That
would
will
be a
be 5.
paragraph 5.
Well, if
Philip,
I,
have you got this?
yeah, if I
And then
might, the way it's written right now,
Three different places.
yeah. The-
Exactly where are we?
Well, we're still in discussion.
Okay, that's
Yeah.
what, yes.
Yes,
Still in
nothing-
I'm
discussion.
waiting for you to
So,
decide what you're gonna do
with-
before I start writing.
With respect to the paragraph, and I understand what you're saying, the way it's written right now, the department shall respond, is in reference to the council providing the recommendations for improvements, service quality, and quality assurance.
Right.
If we are to insert this line from Ms. Patrick into section 4, I think it muddies the waters because the qualifiers refer only back to the recommendations for improving service quality. If you put this in here, I think you leave open the interpretation, the possible interpretation that any communications have to be responded to from the department within writing, within 30 business days. And that's not the intention of this.
Right.
The intention is that these quarterly communications deserve response within 30 business days, and then following the response, the next council meeting agenda, it's on the next council meeting agenda. None of these things apply to what Ms. Patrick has put in to add the opportunity to continue communication outside the framework of these very specific recommendations. So I just think we're muddying it by then putting the qualifiers for the recommendation after don't worry, we can still talk about stuff.
Senator Carson.
Okay, I see your point,
Yeah.
Senator. So would people want to make section 5 this language?
Yes.
So this language here, this quarterly limit, this will be a new section 5, and then we would renumber
Bump
5,
everyone 6, 7.
6 and 7, yep.
and 7. Is that,
That's much easier for
that's
Philip.
much, okay, yes.
So
All right.
this language
Okay.
from Ms.
Yeah,
Patrick
I just got it from.
will be section 5.
That's going to be turned into section 5.
Yep. And it will refer back to section 4. That's sort of what you were asking me to do in the beginning. You're good with that?
Yeah, that was what my concern
Okay,
was.
thank you.
Okay. Do we need to wordsmith this new thing here? Because now we're going to be, this quarterly limit,
As described in section 4 is
4.
not intended to restrict the council's ability to comment on rules, regulations, proposals.
so we need to leave that language in concerning as described in section 4.
Yes, because
Okay.
we're making it section 5.
Okay. Okey-doke, I think we got it.
Philip, are you clear?
So that email language,
Yes.
adding as referenced in section 4.
Well, no, that's in the email language.
That's in the email.
Oh, yes, yeah.
This quarterly limit as described in section 4.
Oh, yeah.
Yeah.
Okay.
The other,
Leave that in, and that's being put in
as section 5.
as section 5, and
Yes.
5 and 6 will be renumbered.
Yes.
Gotcha.
And then the other one is on line 30 on page 2, changing interpreting to clarify.
I did get that.
Okay.
Yes. Okay.
Other changes to the amendment from the committee? we ready for a vote?
We're accepting the amendment first?
Yes, we
Yeah,
did, we had an ought to pass motion, Phil, on the amendment?
On the amendment.
Okay.
So, and then you have the motions made changes.
Yep.
So my feeling is we'll make these changes and put them through, and if the department has an objection, then we'll discuss that. We could always do a floor amendment if we needed to. Fair enough? There's no one here from the department, so. I don't think this changes the structure of the bill or the intent.
You're from the department, aren't you?
Oh, I'm sorry, you are.
I'm like, yeah, I remember
they
you
are.
were here first, so the
My
department was
apologies.
here.
Would you like to comment on this? I'm sorry, I was in my own world this one.
That's okay. Good morning. For the record, Melissa Nemeth with the Department of Health and Human Services. And I did discuss this with Ms. Patrick a little bit this morning, and I don't have the language in front of me. She did show it to me, on an email, but I don't have it printed
Would you like a
out.
copy of it?
If I could, that would be helpful. And I think the department is in agreement with the intent behind this.
Go in, add in, right there.
Okay, thank
And then
you.
number everything.
Thank you. I guess the only one concern I would have is that the intention was to close the feedback loop, and so here we're all in agreement that these more formal recommendations. So, making it clear that there's, even if they provide something outside of that context, which we would, we're not saying we do not want to hear from them, that there's no. It's clear there's no expectation we would necessarily respond back in this formal manner. So it feels a little bit conflicted where, the overarching goal was to close the feedback loop. And now we're saying, we'll still hear from you, but we're only going to respond if it's in there quarterly. I think it's a little bit of a hard balance to strike. And as I was talking to Ms. Patrick, is that, I don't know how best to strike that balance with legislative language. So I think it's a little tricky. And I did want to point out that the other elements, say, for example, if we are going through the rulemaking process or there is a waiver amendment proposed, those, I think that was their concern, and we would have said that doesn't fall under here anyway. Those have their own processes that are totally independent. We, as the department, solicit that feedback. So those are the types of things that we definitely would see falling outside of there. So I don't know if it makes sense to nuance this language a little bit to say, and I got the impression from Ms. Patrick that she wouldn't be supportive of that, and I understood where she was coming from. If we were saying things like, if the department was soliciting feedback through a different process, obviously that would not be impacted and they would not be restricted to quarterly. But where this is kind of broad and saying, comment on rules, regulations, proposals, or other initiatives, I just felt like it was kind of broad, and as long as everyone understands that, the department may not have the capacity to respond in this formal manner or be required to, then I don't think that the department has, a big problem with it. To Senator Perkins-Coca's point, I think the department felt that it's already there, and if John Williams were here, he would probably say this is the belts and suspenders approach, to make it clear to everybody. So I will take it back. Will those higher up than me have any comments? I don't know. I anticipate probably not, but I did want to put that caveat out there that that's sort of, seeing this for the first time and this is happening kind of quickly. Those were the department's kind of initial reactions.
Thank you. Any questions from the committee? Okay. Thank you. We appreciate your input. What do you guys want to do with this?
I want to keep going forward, or we've.
Okay, we have a motion.
Yeah.
Everybody's good with
Yeah.
what we're doing? And I would
With
say,
committee amendments and all the things, yeah.
If we find that the department does have some major objection, then we can certainly do a floor amendment if we need to. We're all in agreement.
Don't forget, Mr. Chair, we always have committee conference.
That's correct. Okay,
So,
further comments? Ready for a vote? You're clear on what we're doing? Okay, we're adding section 5, Ms. Patrick's thing, and changing the word clarifying. All right, all in favor, say aye.
Aye.
Any opposed? And we have a motion about to pass as we had those motions already, whoever brought them forward.
Yep.
All right, so now we're voting on the OTPA using the amendment 1452 as changed by the committee. So I guess it won't be that number, it'll be the committee amendment, excuse me. It'll be the committee amendment. All in favor, say aye.
Aye.
Any opposed?
Move consent.
Consent has been moved and seconded. All in favor?
Aye. I can take it out.
You want to take it out?
Sure.
All right, Senator Perkins Polka will take this one out. Thank you, good work. Why don't we look at the bills we heard today? I think there's at least a couple of those that we can move. I'm just trying to find the numbers, there we are. I think House Bill 215, that was the LNA licensure, allowing the Medicare, I have the wrong terminology, so I'm going to stop for a minute till I get to it. I don't have the right terminology in my head here. That was expanding the reimbursement program.
Right.
There we go. Do we have a motion on that?
I'll make that move.
On to pass?
I'll second.
Moved and seconded. Discussion.
Everyone seems to be in agreement.
Do it.
Mr. Chair.
All right, hearing none. All in favor, say aye.
Aye. Helping us out.
Any opposed?
Moves consent.
Second?
Consent's moved and seconded. All in favor? Senator Gendro, would you like to take this one up?
Sure. Today's the 26th. 26th?
Yep.
215.
26th. Thank you.
Okay, how about House Bill 136?
I move on to pass.
Second.
Any discussion from committee? That was the last one we heard. 136. It's one relating to the PDMP Council.
Right. Authorizing roll call votes. DHHS supports it, so.
Further discussion? Seeing none, all in favor?
Aye.
Any opposed? We have consent,
Move consent.
Second.
moved and seconded by Senator Carson. All in favor? Would like any volunteers on bringing this one out?
I can do this one too if you want.
All right. Senator Perkins Polka will bring this out. That is 136. I'm just gonna write PK, it's quicker than writing Perkins Polka.
I do go by RPK, so you're in a good company.
Yeah, because that's what I'm doing, because I put down floor and then I just go P-K. So,
Okay, so,
Mr. Chair, just to update you and the committee on House Bill 421. We had a meeting of the stakeholders last week. Senator Whitley, myself, Jane Graham from the Commissioner's Office, Ms. Chase who was there, Devin Quinn from the Women's Foundation.
Great.
My God, we had, I think, the commandant of the women's prison, and then we had a warden from one of the counties that was there. We've all agreed upon some language. I did not get that language until last night.
Okay.
So just as soon as I get it, hopefully I'll get an amendment made up and distribute it to the committee, and we'll take it from there.
Great.
okay.
So not today.
Okay.
Now,
337, I'm assuming Senator Carson does not want to act on.
No.
So Director Lindsay is here. Would you like to have?
No, we're gonna, I've set up a meeting with, tomorrow at noon in the Senate President's office.
Okay.
Okay.
All right.
We need to resolve this before we move forward, quite frankly, with anything dealing with OPLC at this point.
So 358, I'm just looking to see what that was. I'm looking at the ones we have open here. I don't remember which one this one was.
The filing and adoption of rules.
Proposed administrative rules.
That's what I hope. We're not touching that.
Oh, we've got a hold on this one.
Okay.
I know we need to do an amendment
Okay.
on this.
I don't even have it.
This, This was the one that Mrs. Virtue came in and raised concerns about rules that were being
Yes,
made
that's right.
by
Mhm.
waiver and not statute. So
Yeah.
I know we need to do a little bit more with that.
Mhm.
All right.
Is somebody working on that?
I probably need to be.
Okay.
I think that one may have slipped through the cracks on me.
Okay.
I know that I have had conversation with Carolyn and I will follow up on it. Okay, 409, we're holding.
Yeah.
421, 454 would be the next one.
I'm sorry, 454, right?
Yeah.
454.
Oh, this was the public transparency advocate. Um, What's the discussion on this from the committee? I'm unclear as to what my thoughts are on it.
Well, if I remember correctly, we had this testimony and this article. I think that was very moving
Yes.
about the New Hampshire Board of Medicine failing to revoke the license. And the fact that none of the 13 malpractice settlements are posted. Yeah,
I guess I wasn't 100% clear as to how this bill fixed that. Because non-public session
I know.
information still wouldn't be posted.
I don't know. Maybe it's not ready to come forward
Yes.
at this time.
Any thoughts from the committee on this?
Lines 9, at least 2 public members of the board who have no medical experience, never were in the medical profession, not even tangentially. I don't know that that's a healthy addition to a board of medicine.
We've got a little bit of time on
Yeah.
this. Do you want to,
I
why don't we?
seriously don't love that.
Okay, why don't we can think on this and what we want to do, and we won't have to act on it today.
Yeah.
Yeah, I will.
Just to let you know, too,
Yeah.
the gal that testified, she's in my district.
Yeah.
Yeah.
So, and it was a very difficult time for them and for their family.
Certainly, and I'm just not certain that this bill fixes that.
Right.
That's what I don't know.
I know.
I don't know if I have my head around that.
Right, and I mean, I will say the fine and the fact that the doctor was able to retain his license, that it seems like an issue, but I don't know that having a public advocate. Yeah, I have concerns about what happened.
Right.
And I take them seriously. It was also very informative to hear, that Georgia is, sort of one of the only states that's displaying these disciplinary cases. So I guess, it would be useful to have more information from OPLC on this, from my perspective, and.
Director, we're talking about House Bill 454.
Yeah, I'm happy to
Come on up if you want.
Sure.
We need, the board, committee needs a little guidance here.
May I perhaps formulate my question better, Mr.
You
Chair, if
certainly
that's
may.
okay with you? All right. Hi, Director, nice to see you.
Nice to see you.
And feel free to respond on whatever feels relevant, but I guess my question would sort of be, it felt to me like the consequences were very minimal in this case, and I know you are not a person who controls what the Board of Medicine were to do, but are there procedural pieces here that we as the legislature could respond to, and do you see this bill as being responsive to that is one question. And then I guess secondly, what is common? Like, is it, do the boards look at other states and how they kind of act on disciplinary actions? Because I was sort of struck that there was only one state that required disclosure, of such an extensive disciplinary record. So those are my two questions that are rather broad.
Yes, so certainly thank you. Lindsay Courtney, Executive Director, OPLC. without disclosing details, I think what the issue here is regarding transparency, and this is consistent with what I've spoken to Representative Pearson about and what I've spoken with the subcommittee that he established about, is that on the transparency piece, one does not, the members of the public do not know of any potential actions until the board decides to proceed with adjudication. So everything that happens prior to that, including review of complaints, review of malpractice claims, even if they are considered public, when we receive them, they're considered a complaint. Investigative reports that don't go anywhere, those are not made public. And I think that that maybe there is a reason for that. Some of the policy reasons for not making those items public is because we do receive frivolous complaints, and there are certain specialties that are more apt to receive complaints by virtue of the work that they do. On the flip side, if there is a pending complaint and a pending investigation, and it takes a while, one as a member of the public may want to know that. So one of the things that we had suggested as a potential policy change would be to have some point in time in between from when you receive the complaint to when you proceed to adjudication that you would make those documents public. We had suggested maybe an order of formal investigation, which is already the process that we employ. I don't think stakeholders were ready to move on that suggestion, which is fine, and that's just one policy suggestion. But at the end of the day, I don't think this bill is going to get the public what it really wants, which is more transparency in the process. Regarding what we display on our website, some states, it appears Massachusetts actually interfaces with the National Practitioner Data Bank. I'm going to find out how they do that. I don't know legally and practically how they do that. But they report all of the malpractice payouts. They report somebody's criminal history record. That is not something that we do, nor is that something that we're presently authorized to do by law. So if you look at some of the Globe articles, there's a comparison there, and there is a statutory reason why we can't do that at the present time, if we even wanted to from a policy standpoint. Regarding looking at other states, the board does have the ability to discipline from a reciprocity. It's considered reciprocal discipline. I think what we heard is that, and from the board chairs, that historically the board had declined not to do that if they were previously disciplined in another state. I think as part of our profiling project and internal controls project, we are working with the board on that, and that they're moving in a different direction. So that could explain why they have a tendency to take fewer disciplinary actions than other states.
Okay.
So are you saying that when the New Hampshire doesn't take into account on the application of a license to practice medicine previous complaints in other states? That's not part of our evaluation process?
Oh no, certainly that is. Certainly that's a standard question for every licensing application. And in fact, we just promulgated rules to create a universal application that it also included that question. What's shared with us outside of just a self-report will be based on whether it was reported to a National Practitioner Data Bank or there was some sort of discipline. So we rely heavily on self-reports unless there's some documentation reported elsewhere in a database that we can access.
Do we use, are you saying I'm trying to follow along, you use that database, like outside of the self-report, New Hampshire also looks into these databases for information that may not have been included in the self-report?
Correct. So medicine is actually highly advanced from a technological standpoint. We're a member of the Federation of State Medical Boards, and we are able to log in, and they have what's called a physician PDC, physician data something or other. I don't know the acronym, but essentially we can get everything on a physician's professional history at a
moment in time, and that includes a report from the National Practitioner Data Bank, that includes payouts, that includes their educational history. Basically anything that a licensing board would need to know, we can access it at any time. So we have that information, but what the board chooses to do with it is up to the board.
So back to this bill then, does this address in any manner that concern about getting transparency, which is what the bill's going after?
I mean, I think the intent is there. I just don't think that it'll fully address the issues that were raised this past fall.
Further questions?
Yeah,
Senator Olson.
so when you're using the information that's coming out of the federal, state medical boards and evaluating a license, either for, a first time or a renewal, is the information gathered available to be reviewed by the public?
No. Most of that is considered confidential. I mean, if somebody were to request it, we would, like Doug mentioned previously, regarding 337, we would download it. We would have to go through a legal review. We'd have to redact all the PII, the educational history has FERPA consequences. There's a whole host of analyses that needs to go into part of an application as to whether it's considered disclosable under 91A.
So that if there's disciplinary actions or payouts from claims, is that available to be viewed?
It's not available to be viewed under a 91A request. I don't know that that would be considered public either, because the public can't access, and this is what I mean by, I don't truly understand how Massachusetts publishes all this information, and it's something that we are meeting internally on. But because we receive it in a confidential manner, we'd have to take a look at that. I'm not sure that we would disclose that under a traditional 91A. Certainly, like for example, if a malpractice complaint is considered public, you can go to a court and get it. But if we receive it, by virtue of the fact that we received it through a complaint fashion, we can't disclose it, even if it would otherwise be considered a public document. So that is something that we have to take into consideration.
And so would the board be bound by those same rules as OPLC is?
Yes.
Not being able to disclose it. Okay.
Right.
All right. That kind of answers my question.
Okay, so if there, may I, Mr. Chair?
Yeah.
Yeah, so if there's a complaint here that's available to a citizen of New Hampshire to go to court and request that, they can do that. If they went to you, you can't tell them. They have to go the other way. So additionally, if there is a complaint from another state that they had practiced in that OPLC is aware of, you can also not disclose that, but they may be able to go to that state, but they would have to know that there's a complaint from that state, which would be public information.
Right.
So once it gets to you, it goes under a shell.
Right, because of the statute, RSA 329 says that basically anything prior to adjudication is off limits. We can't disclose it, even if it would otherwise be considered a public document.
But
Go ahead. Yeah.
Mr. Chair, yeah. But something that has been adjudicated.
Something has been adjudicated, if it's part of the formal docket file, would be subject to disclosure.
And is the current practice for the Board of Medicine to disclose those?
Yes, upon request. So if anybody wants a docket file, we can certainly provide that. I'll say what's in a docket file is not necessarily what everybody is looking for. It's, motions, filings. The evidence can be pretty limited by the time you get to adjudication. It could just be testimony. We probably wouldn't disclose medical records. Those are typically sealed because it's a third party involved, and that's often evidence.
A final decision.
Certainly a final decision is posted both in our licensing portal, in the National Practitioner Data Bank, and on our website.
Okay.
All right. Further questions? Thank you.
Thank you.
Appreciate it.
Thank you.
Sure.
All right, what do you want to do with this? You want to think about it a little bit, or?
Yeah,
Yeah.
can we sit on it?
We have time.
Yeah.
Okay.
Marinate? Yep, thank you.
Marinate, that's a great word. So, House Bill 532 is one of the bills we're going to use with putting together some of the changes that we wanted to in 655 and any other changes that we wanted to make. We have those two bills, 532 and 409. Senator Perkins Quokka has handed out an amendment that she started to work on that's putting together some of the changes that we are looking at. This is certainly a first draft, and I'll let you speak to that if you want.
No, that's fine, yeah, I mean, to be clear, I would love to see 532 pass because I think it's important. However, being made aware that this might be the vehicle for the changes to 655, I have brought the committee amendment. It's available if anybody would like to see it that has not seen it. I'm trying to circulate it widely for feedback, but the intent is to capture feedback from the hearing. And then, you know, I'm in close coordination with our House colleagues to make sure that anything they're working on is not something that we are simultaneously trying to work on. So that's the intent.
So I would say to the committee, yeah, as you review this, if you have other changes that have come to you that we want to propose that we'll eventually work on in one large amendment rather than having 5 different ones, I think would be better. I'd certainly all would like the committee to look at the changes too as thinking about what might be things that the House would be amenable to versus some things that might be contentious, because we do have 2 different vehicles of doing this and we maybe can separate them in that manner. So just something to be thinking about. Okay, that's all the bills that I have on the sheet. Anything further that the committee would like to discuss?
Did we discuss 250 or am I
250.
wrong?
Did I miss one?
Did we already accept that? Oh, we did? My bad.
Okay, no, that was done.
We already did.
I had it in the wrong pile.
All right. Any other business? Seeing none, I'll take a motion to come out of exec.
Oh, one last question, Mr. Chair. Do you anticipate, like, will we be meeting next Wednesday, the Wednesday after? Just maybe
So
share some thoughts on
We
schedule.
do not have any bills left to
Yeah.
hear, correct? We've heard them all. So my anticipation is next Wednesday, we probably can take a break. And then we can meet 2 Wednesdays from now. And
Okay.
do some final execing, and that'll give a chance for us to but I'd like everybody to be looking at the changes that we want to make, because we will probably have to exec 532 2 weeks from now.
On the 9th.
10th, I think.
Yes.
10th, I'm sorry, the 10th.
Yep, so that works out well.
So unless you all feel we need another meeting before then, I mean, certainly, I think we could take a break next week.
That sounds good.
All right.
All right,
Thank
so we are not meeting on the 3rd.
Motion to come out of exec?
So moved.
Second.
Moved and seconded, all in favor?
Aye.
And our business is complete for the day. We will adjourn. Thank you all.
Thank you.
So we are not meeting on the 3rd.